in the first part of my submissions, I'm going to assume that there is. I have factual challenges to that, but for present purposes, I assume that this is the sort of public meeting that attracts the privilege. And then at that stage, the publication is privileged unless shown to be made with malice. And it's agreed that the burden of showing malice falls upon the defendant.
Did you mean to say that?
The claimant, I think. No, I didn't mean to say that at all.
I thought you'd probably just misspoken that.
I misspoke, sorry. Yes,
it's very easy to misspeak when there are double negatives.
Double negatives.
I think I may have done so myself earlier on.
Section 15.3 disapplies Section 15 altogether, unless the dual components of 15.3 are satisfied. And then if I can go on, that's the structure of Section 15. If one then looks at what's being protected, it's the reporting. In Section 15.1, it's the report of a meeting which qualifies, and I'll look at it at the moment. Section 15.3, of course, is concerned with matter, which is not of public interest and public vocation, which is not for public benefit. But if you go to what's being the nature of the event, which for the reporter is attracting the privilege, you need to look at Schedule 1, Part 2, Paragraph 12, and that is at begins at 23 of your authorities. And as I say, I'm at the moment assuming all of this is satisfied. So 12.1, a fair and accurate report of proceedings at any public meeting. And then 12.2, public meeting is defined. It needs to be bona fide, lawfully held for a lawful purpose and for the furtherance or discussion of a matter of public interest, whether admission to the meeting is general or restricted. Here, the furtherance or discussion of a matter of public interest needs to be satisfied in respect of the meeting, which in this case took place in Sargodha in the Punjab. And I'm assuming it has been for the purpose of these arguments. That's because what Schedule 12 is doing is gathering together other public events which take place at a similar pitch. So, for example, in paragraph 13, I beg your pardon, go back 2 pages, paragraph 11 at page 22. So this is immediately preceding 11A, which is press conference, and then 12, which is public meeting. In 11, what attracts to the reporter a privilege is a fair and accurate report of proceedings at any public meeting or sitting in the United Kingdom of a local authority, justice or justices of the peace, other than sitting as a court, a statutory inquiry at sea, a local inquiry or a tribunal, board, committee or body constituted by or under exercising any functions under any statutory provision. So the public interest requirement in Schedule 12 is bringing the meeting in question up to scratch with the other comparable events that the schedule, if the meeting qualifies within the schedule, allows the reporter then to claim a privilege in respect of fair and accurate reporting. The fair and accurate reporting is then for the public interest and for the public benefit in England and Wales, where the report takes place. It's to inform the public about what happened at the meeting that is qualified. But for the meeting to qualify, the question of public interest in relation to the meeting is the qualifying condition. And it doesn't have to be a meeting at which things of public interest were actually talked about or things of public interest were said. At the qualifying stage, under paragraph 12.2, the question is it a meeting for the furtherance or discussion of a matter of public interest, full stop?
Logically, I can see you could have a meeting which was for the furtherance or discussion of a matter of public interest, but it would be surprising then if at least some of the matters discussed there were not themselves matters of public interest.
Well,
I think you're pointing out it doesn't necessarily have to be so, but
no.
Where does that get us?
Well, what it does do is allow the court to draw a clear line between the qualifying condition in paragraph 12, which is it a meeting that will qualify the reporter for privileged reporting, which then needs to be distinguished from what's going on in section 15.3, which is raising the question, is the reporting for the public benefit and of public interest, whatever the formulation is?
Well, for the moment, obviously I see that at the level of theory, but my point of my question was, where does that get us in this case? Why is this distinction that I see theoretically correct important?
Well, it's important because on our reading, the bid that is made for some sort of presumptive quality about section 15.1 is essentially, I mean, the way in which ground one of the appeal was framed, and ground one is at
16.
Thank you. It's at 15 and 16. Ground one it is criticising the judge, and it's 4 lines down into paragraph 1 at page 15. Having found that the broadcasts were a fair and accurate report of proceedings at a public meeting held for a lawful purpose and for the furtherance of a discussion of matter of public interest, the judge should not have ruled whether or not the publication was of matter which is not of public interest and the publication of which was not for the public benefit was an issue that required resolution at trial. And it seems to us that what's being attempted here is an elision of the paragraph 12.2 qualifying condition. Is it a matter? Is there furtherance or discussion of matter of public interest? An elision between that, which is about the nature of the meeting, and what's required by section 15.3, which is about the public benefit and the public interest in the reporting. And so, to answer my Lord Justice Underhill's question, in a perfectly run public meeting at which all matters discussed are properly of public interest, then the qualifying meeting ought to result in reporting which is of public benefit and public interest. But as soon as you descend from theoretical and get into the facts, you get a situation like we've got in the present case. The meeting in Sargodha seems to have gone on for some hours. It was trailed as a meeting that was going to be addressed by the Chief Minister of the Punjab and ended up being addressed by Ms. Nawaz Sharif as well. And the complaint that my client makes is the 3 sentences or 3 paragraphs that were read out to you before lunch. And we say that certainly, well, this will be the submission at trial as well, but you certainly can't get from a qualifying meeting in the Punjab at which the First Minister of the Punjab and various other people will speak. You can't get from that qualifying as the sort of meeting that might give a reporter privilege in reporting it to satisfying the requirement in section 15.3 that indeed the matter reported is a public interest and for the public benefit. And the reason that the reporting of Ms. Nawaz Sharif's allegations are not for the public benefit, and we would say therefore not in the public interest either, is because they have long been discredited and established as untrue. So how is the public benefited in this reporting by being given such grotesque allegations, completely unmoderated, completely unqualified?
Well, suppose a politician, transatlantic politician, makes in a public meeting long discredited and shown to be untrue allegations. Are you saying that it wouldn't be in the public interest to report those?
Well, we would say it wouldn't be for the public benefit to report those without a caveat.
So every time, I'm trying to avoid examples, but we can all think of them, let's go back in history. about whether the other candidate was born in the United States, you might say long discredited and so forth. So every time that you published that, you would have to say, as the broadcaster, by the way, everyone's seen the birth certificate saying he was born in the United States.
Well, why would it be in the public benefit not to caveat that?
Well, I wasn't suggesting it was in the public benefit not to caveat that. I was merely suggesting why it was necessary to caveat that. The fact that the allegation has been made, you're saying it can't be in the public benefit unless the reporter adds their own view that it's clearly untrue.
Well, it's their own knowledge that it's clearly untrue. And in this case, you've got evidence on behalf of the respondent that each of these allegations, the world call one, the gold smuggling one, and the tax one, are untrue.
Sorry to interrupt. I'm having difficulty with the notion that it matters that the defendant knows for this purpose. The real proposition here, surely, is that it's not for the public benefit to publish untruths. Yeah. And if that's the basis on which Section 15.3 excludes matter from the scope of the privilege, it's a privilege that's almost worthless in a case where the claimant is saying that what's been published is untrue, which is almost invariably the position, because the truth is always going to be available to the claimant as a rebuttal of the privilege.
Well, no, it's not worthless, because if the public benefit has been deserved in that way, the claimant has a remedy, and the privilege isn't available. The problem, a problem here, is that we're honing in for this argument of principle on 3 paragraphs from a much longer address. My client isn't making any complaint at all about what went on for the other 3 hours or...
It's got nothing to do with him.
It's got nothing to do with him.
Why would you complain about it?
Yes, but the privilege is being claimed in respect of the report of proceedings at the meeting. Now, the judge didn't define what the proceedings at the meeting are, but if you narrow it down and say, well, the nature of the complaint is in relation to the 3 paragraphs, that's what she said. It's long established, long discredited and established as untrue. The public benefit has not been served by the repetition into England and Wales of these defamatory allegations that are known to be untrue. The public has been deserved by this process. Now, at this stage, I would accept my Lord Justice Warby's point that that is neutral as to what the broadcaster knew. But the judge identified that Section 15.3 is an objective question of fact. He cited Mr. Justice Tugendhat in that respect. Later in the judgment, he involved himself in consideration of what the journalist knew and so on, which was, my submission, just a way of summing up what was generally known at the time. It wasn't looking properly at the actual knowledge or even the objective knowledge of the journalist. But the problem, and the reason why Section 15.3 needs to go first, is to identify, if we're talking about reporting that served any public interest or the public benefit in England and Wales, before asking ourselves the question, was it in respect of anything which qualifies under Section 1? What we can't do is take the qualification under Section 15.1 and paragraph 12.2 of the schedule and then double count that as having ticked the box for public interest under Section 15.3.
Can I just ask you a question? Why, on your analysis, aren't you starting with 15.4 if you're looking at the whole section together? And 15.4a, surely that's where you would start. And then 15.3, and then go to 15.1.
Well, I'm starting with, I take the point, I think. I'm starting with section 15.3 because it begins with the words, this section does not apply. So this section does not apply to the matter which is then identified in that section. You're right. I mean, the section 15.4 then limits the protection as you indicate. And it may be that you need to read that as well before you get to section 15.1. But my submission is that you don't start with section 15.1 because if you do, you're going to create these difficulties over, well, if nothing else, trying to assess malice, as Mr. Justice Tugendhat was trying to assess malice in Qadir, assuming that everything else had been satisfied, whereas in fact the proper analysis, if section 15.3 is satisfied, is don't go on and consider malice because section 15.1 doesn't apply. It's been disapplied by the wording of section 15.3. And one could say that also about the passage of Miss Justice Nicklin in Harkham that we were looking at before lunch, which I think Lord Justice Underhill found some difficulty with. Because once the judge has decided that this is not of public interest, not for the public benefit, the section's disapplied. The privilege isn't available.
So that approach, your analysis, would apply to any case under Section 15. In every case where a Section 15 privilege was relied on, including those in Part 1 of the schedule, you would have to start by asking what public benefit is served by publishing a report of, let's say, legal proceedings held in public in England and Wales. It's not confined to reporting of foreign material.
Well, but you wouldn't ask that because, for example, you'd have Miss Justice Eadie in Crossley saying that things that go on in Her Majesty's Court are intrinsically of public interest and for public benefit, and we all ought to know about it. So it wouldn't be. It's part. I mean, I would say it's part of the consideration, but the reason why those court proceedings, for example, will be reportable under conditions of qualified privilege is because of the importance and the centrality of them, as reflected, for example, in Crossley, or the point that was made in Jakarta about the quasi-judicial process that was gone through there, so that the subject of the defamation had the opportunity to turn up and state his position and so on and so forth. And the outcome that was reported in Jakarta was the product of a quasi-judicial process. And so when the judge, later on in his judgment, is talking about the status of the information, in my submission, what he's driving at is the status of information emanating from the Worcester County Court in Crossley or the judicial inquiry in Jakarta. And remember, the Court of Appeal, after a full trial process, were very, very marginal in Jakarta about whether or not the privilege was upheld. But what the judge was doing below, in relation to status, was looking at Jakarta and Crossley, the Worcester County Court, and comparing it with the status of the information emanating from Sargodha in this meeting that, at this stage of the analysis, has qualified as a meeting under paragraph 12.2 that I'm not looking behind. So it's already qualified as a meeting, but which is going to be for the furtherance or discussion of matter of public interest. What the judge was doing was saying, well, yeah, that's what the meeting was about. But now, what happened at it, and what was the quality of the information that came out of it? Because it's the information coming out of it that ends up being reported under conditions of privilege in England and Wales under Section 15.3, with the public benefit and the public interest being established. But so my Lord Justice Warby is right with respect to say you need to think about this in every case. But you don't really need to think about it if it's the county court or if it's the judicial inquiry in Jakarta or it's the Supreme Court. But the reason that fair and accurate reporting of the Supreme Court is under qualified privilege is because intrinsically it will be satisfying Section 15.3 of the Act. One can't say the same in respect of other events, and I would include in those other events this meeting in Sargodha, even though it qualified for as a meeting which the reporter might claim a privilege in respect of. I'm going to come on in a moment to Lord Justice Warby's questions, before I do that, if I can just complete what I was hoping to say about Section 15. I think I've drawn out the bright lines that I suggest the court should see. It's important to recognise that below the evidence that was given on behalf of the appellant here, the applicant in the application for summary judgment, was, and this is reflected in what the judge says, and he's making a fair assessment in my submission of what he says about the evidence, was extremely limited. It was also very formulaic. And in fact, what one, without needing to look it up, but in Mr. Chagtai's first statement, there are at least two occasions in paragraphs 9 and 17 where the whole Schedule 12.2 condition is elided with the Section 15.3 public interest and public concern. So we get in Mr. Chagtai's paragraph 17, the reporting of Ms. Sharaf's speech was clearly fair and accurate reporting of a public meeting and press conference of public interest and for the public benefit. That's all one sentence. That's actually what the judge has got to decide whether it's arguable or not. So you could say, well, it's worthless information from the witness, or it's opinion from the witness, or it's the witness trying to provoke a legal conclusion. But what it isn't is anything objective. There is no objective factual material beyond the judge's assumptions that the meeting qualifies under paragraph 12.2 of the schedule.
You say assumptions, do you mean?
Well, where he said, I've got no realistic prospect of showing it wasn't a public meeting.
Yeah.
But beyond his conclusion that I've got no realistic prospect of showing that it's a public meeting for the purposes of 12.2, there was no information or evidence at all from the applicant below which would amount to any objective factual scenario upon which the judge could conclude that Section 15.3 had been satisfied. And certainly, I'd understood it to be common ground. It's not been, I don't think, it was only lightly disputed today, but we've all been proceeding so far on the basis that Section 15.3 contains two factual questions for the judge to decide, as well as all the factual questions about whether it's a qualifying meeting. So it had been common ground that public benefit and public interest were factual questions in the argument below. But as I say, there was actually no material in the evidence that was put before the judge from the applicant that would allow him to get from the qualifying meeting satisfying paragraph 12.2 to add something special to turn it into Section 15.3 where the reporting was of public interest and for the public benefit. Now, Lord Justice Warby's questions, it's probably predictable we're not going to agree with...
Well, they were questions, they weren't propositions.
Propositions. On the first one, this is the question about the first of the exclusionary criteria, whether it's limited to removing the scope of the privilege, from the scope of privilege, things said at the meeting that didn't relate to the purpose of the meeting, if I can put it that way. I said in my respondent's skeleton argument, I had seen Lord Justice Warby's propositions. I hadn't actually seen paragraph 46 of the appellant's skeleton, but the fault for that is mine. But I did say, I did make the point in the respondent's skeleton that this wasn't an issue and there was nothing in the grounds of appeal about it. But there we are. We say, though, that the answer is no, And the answer is no, largely speaking, because of the way in which I've suggested the section should be analysed. It's not a question of setting up the privilege under section 15.1 and then using section 15.3 as a filter. Rather, it's a question of asking yourself, does section 15.3 allow section 15.1 to allow the privilege to arise subject to malice? So that's why the answer would be no. And aligned with that is my point that you can't double count public interest in 12.2 with public interest in section 15.3. And so we do say actually that the proposition, as it was put, would fall into the same trap of analysis that I've suggested the appellants are guilty of here. That's question one. The second question was concerning, proposition was concerning section 15.2. This was whether the court's approach to the publication of which is not for the public benefit be different in a case as opposed to the one where, as in Chikata and Kadir, there's no right of reply. But again, not before the judge below, not raised in the grounds, but we say the answer here is no. Section 15.2 provides, we say, an additional statutory mechanism by which a section 15 defence can be denied if the mechanism is invoked, the various variables under it, suitable manner and so on, are justify denying the defence. But that is entirely neutral as to how section 15.3 operates. Section 15.3 would apply to disapply section 15.2, but if section 15.2 hasn't been disapplied by section 15.3, then it's entirely neutral. And one of the reasons is that given by my Lord Justice Dingemans this morning, as to the random results one could achieve for individuals with better or worse advice, more or less able to raise section 15.2. So it doesn't, we say, section 15.2 doesn't shed any light on section 15.3, and certainly it shouldn't be the position that where a respondent, or sorry, where a claimant is receiving the best available advice and so on and so forth, he shouldn't be disadvantaged in his quest for liability in a libel case by the fact he hasn't gone down the mechanism of section 15.2, or with the result that section 15.3 should therefore be interpreted in some way differently in respect of him than someone
No, I had
else.
in mind a different point, which wasn't interpretation but application. The point is this: the public benefit of publishing something which is objected to may be greater or lesser according to whether there's a statutory right to have a reply or the privilege gets lost.
Yeah.
No, it's not a point. It depends on the particular facts or what advice the individual claimant gets. But I think your answer is the one you've already given.
Well, I was actually going to elaborate down the direction you've gone, because there were some interesting exchanges with Mr. Speaker about this. His submission was that section 15.2 is a means to enhance information available to the public. That seems to be a desirable thing, to enhance information available to the public. But why in that situation, on the facts that we've got here at least, or even in principle, if the broadcaster defendant could have enhanced information available to the public by reporting that Ms. Nawaz Sharif's allegations had long been discredited and established untrue, why is that not a matter which ought to be judged in the context of section 15.3 when asking whether the matter is the publication which there has been publication of matter which is for the public benefit. So if the appellants are going to say section 15.2 is there to enhance the benefit to the public, well, I accept that. But why then was the public benefit not served here by the caveat being entered on the reporting of these long discredited, established as untrue allegations? On the question of the the two exclusionary criteria being cumulative. Well, the answer is that they are cumulative. I probably don't need to go further than to refer the court to the words of the Act, which Lord Justice Underhill has already done. It may be useful, actually, just for a note. Baron Huddleston was giving his judgment in 1889. You'll see from Gatley 17002, footnotes 7 and 8. I don't think you need to look them up. I can tell you what it says. What he was doing is he was considering the 1881 Newspaper Libel and Registration Act and the then recently enacted Law of Libel Amendment Act 1888. What the footnotes in Gatley at 17002 record is that the first act, the 1881 Act, in the relevant part, required that published matter was, quote, for the public benefit. The 1888 Act then expanded that and so excluded from the defence, quote, any matter not of public concern and the publication of which was not for the public benefit.
So the double negative only comes in 1888?
1888, and it was said by Gatley to be an expansion of 1881. And so 1 year...
Excuse me, Mr. Assessor.
So soon?
Do you mind not...
Yes, so the cumulative language came in 1888. Baron Huddleston had first go at it in 1889, and it's been settled for, I was going to say 130 years. I think Lord Justice Warby was suggesting just under 140.
That's because my arithmetic is
again, there was no dispute about this below. I cited Kelly and O'Malley's authority for the proposition, and there was no demur. As for the law not being clear and so on and so forth, I simply refer the court to the language of the statute. It's obviously a dual requirement. Mr. Speaker, in this context, observed that there would be a more significant burden for the defendant if these requirements were cumulative, and obviously there would. But that's really playing into the importance of the constraints that there are on this privilege. It goes right back to the significant points of policy that Lord Bingham was making in McCartan. So it is more significant for the defendant in principle if they've got to establish two things rather than one. But it may be the parties in this appeal agree on the final part of Mr. Speaker's analysis, which is that in the real world it probably doesn't make any difference. It's difficult to envisage something not for the public benefit that is in the public interest, or vice versa. But so far as the language is concerned, obviously the case is that they are two separate requirements. With that, that really is introduction in section 15. I was much of the main part of ground one I've already dealt with, but I was then going to deal with the sub-grounds of appeal, which, if you need them for reference, are at pages 15 and 16 of the core bundle. The first sub-ground 1A is that the judge erred in law in failing to construe the subsection properly or at all. Well, I say that doesn't really add anything. I've got nothing more to say about that. The second point is that he applied too high a test for the appellant to have to meet. Well, we obviously differ on that. The complaint seems to be that where the judge was directing himself and citing Miss Justice Tugendhat in Kadir, he permitted this judge permitted himself to read into his judgment the theoretical observation as it was described by Lord Justice Buxton of Miss Justice Tugendhat, that the balance within section 15, and we accept it's a statutory balance, is similar to the res balancing exercise. There are also points made about the permission to appeal, where the judge is referring to all the the circumstances points, but in my submission,
page 105.
Page 105. Sorry, thank you. I've lost it. I had lost it.
Balancing of all the particular facts.
Yes. So there's in the second paragraph, balancing all the particular facts of the case. I mean, the criticism of the judge there maybe is he could have included the word relevant. He clearly knew that he was doing a balancing exercise under section 15 rather than a res intense focus. He certainly didn't do a res intense focus anywhere else in the judgment, and the appellants don't suggest that he did. And then later on he says, depending on the facts of the case, this might include consideration of the status of the information, what ought to have been known, as well as the wider circumstances. Well, again, just because he's referring to the wider circumstances, it doesn't mean to say that he's indulging in or he thinks that res is the approach. And you can see from the direction he gave himself that he doesn't think that. The error, if he made it at all, seems to be including that one sentence from Mr. Justice Tugendhat about the res similarity. If one goes to the judgment, which is in tab 6, and it may be helpful actually to look at the structure of it in this context. It's at page 92 of the core bundle. So he begins at 57, acknowledging the McCartan point. At 58, he then directs himself that public interest and public benefit are cumulative requirements. That was common ground before him. Whether such a report has been published on a matter of public interest and for public benefit is a question of fact to decide it objectively. He cites Qadir, and then he cites Mr. Justice Tugendhat in Qadir, including the fateful final sentence of the citation at paragraph 100. He then goes and discusses Qadir, which was about the particulars of claim obtained from the court office. What he then does, and I'm just outlining this so the court understands how we say the judgment is structured. From 61 through to 67, he is discussing the status of the information that emerged from Sargodha, especially in respect of the status of the information in Crossley, which is the Worcester County Court, and the status of the information in Sikata. And that's the passage in relation to status, which can then be traced through to his rounding up reason at paragraph 81, as to the reasons he gives for dismissing the application. What he does at 74 through to 79 is he recounts there, there are a number of sources for what he's doing, but he's essentially recounting the factual information that he's been given by the appellant's witnesses. That's led to the criticism of him that he's taken into account too much what they knew or what they should have known. He might have here set out the knowledge of the respondent's witnesses, which would be the negative. Well, in some respects, Mr. Rana agrees it's all untrue. But anyway, that's what he does, and that then leads him at paragraph 83 to the second reason he gives, overall reason he gives for dismissing the application, which is the question of what was known or arguably should have been known by the defendant. Now, there he is certainly talking in terms of what the defendant knew or should have known, but the reality, the substance of the exercise is he derives between 74 and 79 from the mouths of the applicant's witnesses what was the state of knowledge of the matters upon which the defendant was reporting. What he doesn't do in my submission is depart from his self-direction in respect of Qadir, that section 15.3 is an objective in relation to the facts. What he doesn't do is depart from that. He could have phrased this differently. He could have phrased it in a way which made it look more clearly that he was assessing what the general state of the knowledge was about Ms. Nawaz Sharif's allegations, rather than taking it from the mouth of the applicant's witnesses. But by taking it from the mouth of the applicant's witnesses, he does not, in my submission, fall into the trap of then assessing section 15.3 with respect to what the defendant knew or should have known. Now that's really everything I've got to say about subgrounds 1B and 1C. 1D is that he alternatively erred in law in considering that what the reasonable person in the position of the appellant would do or know was relevant. Further, if that was relevant, was plainly wrong on the findings he made. So, with apologies for any repetition, what we say here is that the knowledge of the reasonable person here is no more than a function of the fact that the dual aspects of section 15.3 are required by the Act and by the cases in respect to the Act to be decided objectively, and that's what the judge directed himself. So slipping into reasonable person language is just a function of the statutory test that he was having to assess. So far as the facts are concerned, and he's said here to be plainly wrong in the findings he made. I mean, what he took from the respondent's factual case, which is explicitly that Ms. Nawaz Sharif's allegations are false and misleading, and the case that they have long been discredited and established as untrue. And for that, I would have taken you to USAF paragraphs 23 to 35, but that was done before lunch, and you see there the case the respondent makes that it's all untrue. So how it can be said at this stage that the judge was plainly wrong in the findings he made when he had that evidence from my witness in front of him with assumptions to be made in my favour, we say is a non-starter. So far as the status of the information is concerned, this is subground 1E. I've made the point already that the status of the information that emerged from Sargodha is important in assessing in any reporting exercise whether to include it or to caveat what is being reported on. We say, but this will be for trial, I suspect not for today, that the information emerging from Sargodha had no sensible status at all, even with the judge accepting that section 12.2 was accepted. When you actually see what she said, it can't have had any sensible status when weighed against the public benefit which is required by section 15.3 here. And in relation to the facts, given the obvious dubious status of the information emerging from Sargodha, the judge was right to be sceptical as he was, at least saying the matter has to go to trial.
Can I just ask on that?
Yeah.
Because if that submission is right, what happens to a broadcaster who wants to cover a foreign speech, who doesn't know what is going to be said, where towards the end the politician goes off message and makes allegations? You say that they don't come within 15.3 at all.
Well, if it wasn't for the public benefit and in the public interest, then no.
But what about covering the speech when you don't know? I mean, you might have thought are you being too specific? Is that a good way of testing 15.3 on that?
Well, you're asking me in principle.
Yeah.
I mean, I don't know how many, one has to calibrate the problem. I don't know how many live speeches from overseas you watch on England and Wales TV. Most of it is either on a delay switch, or it's viewed and then packaged up as a report and reported upon.
So what? I'm not sure what your answer is in a case where that isn't so, where it is alive.
Well, my answer is, in that case, the case Lord Justice Dingemans put to me, my answer is, if it doesn't qualify under Section 15.3, then Section 15 is disapplied.
So, I mean, if one looks, I mean, simply because of the timings, we know that very likely tomorrow, the day after, the news channels are likely to go and listen to the new President of the United States, whoever he or she may be. And no one knows what that President is going to say. And you just say, well, tough, as it were, if they go off message.
Well, yes, although there will be a degree of their being trusted not to go off message because they're the new elected President of the United States. It's rather like the Supreme Court won't go off message. The Worcester County Court won't go off message. The judge in Jakarta didn't go off message. But to make equivalent those sort of events or those sort of meetings with this meeting in Sargodha, which at the moment we're assuming was a public meeting for the further, etc., etc. I say is a step too liberal, to use a word Mr. Speaker did earlier on, because of the harm done to the individual, sacrificing his reputation for what? For what public benefit and in what public interest?
Thank you.
In relation to Sargodha, the status of the information, which really depends upon the process of the public meeting in Sargodha, we know at the moment that we don't know at the moment that there were any safeguards in the processes of the meeting to promote fairness or balance. In fact, the evidence is it was a partial political rally. There don't seem to have been any challenges to what Ms. Nawaz Sharif said. There was no checking her. There was no opportunity at the meeting for opposition. It was all one way. So it was a rally to garner support for the PMLN. Certainly, Mr. Iqbal's contradictory case was not put at the meeting. There's no comparable with Jakarta in that respect. And we know already it wasn't a press conference for summary judgment purposes, at least. But there were no journalists asking questions. There just doesn't seem to have been anything to hold back what was said. Now, of course, that's all well and good. If that's the way that political parties want to conduct themselves, it's a free world. That they can do it like that. But the question you've then got to that needs to be honed in on is, well, that's what happened in Sargodha. It qualified under Section 12.2, but what public benefit and public interest is there in broadcasting an uncaveated report of that in England and Wales? How are we all served by it?
So really a journalist has to, or a broadcaster, has in each case to weigh up the quality of the public meeting in order to decide whether it is there's a public benefit in broadcasting it. And the quality, by which I mean the impartiality, the fairness, the opportunity for dialogue. And if there are none of those things there, they should say, I don't think this is a good enough meeting for me to broadcast. Is that right?
Yes. Yes, they've got to assess the quality of the meeting. In particular, as the judge indicated, it's the status of the information that comes out of it. And so,
well, they won't know the status of the information that comes out of it until until after the event. I don't quite know what you mean, status of the information. But the point is surely more the one I put to you, that a meeting at which only one side effectively gets a hearing, and as you will know, if you study Pakistani politics, it will be in very extreme and contentious terms, is not, there's no public benefit in broadcasting it.
yes.
That's what you have to, that's what...
Well, that's certainly the argument I ought to be permitted to make at trial. But that is the point.
Well, I just want to be clear about that. It's a binary question, isn't it? There's a right answer or a wrong answer. And why is it necessary to decide at trial rather than now? What more will come out that's relevant to that question?
Well, at the moment,
It's being judged on the basis of your evidence.
Yes, but, well, at the moment, my evidence, but at the moment, what we've got from the appellant is information that has persuaded the judge that section 12.2 is satisfied, the nature of the meeting. As I said earlier, there is no further information from the appellant as to what it is about this reporting that satisfied the public interest, public interest and public benefit. So, I mean, the terms in which I originally put my skeleton argument, which Lord Justice Warby denied me permission to proceed, were on the basis that there is so little here that you can determine these points in my favour. But I'm not arguing them today because I haven't got permission to do so. But we do say if all the evidence amounts to a conclusion by the judge that this was a public meeting under Schedule 12.2, if that's all the evidence shows, then Section 15.3 disapplies the section. Because there's nothing to explain public benefit and public interest in the evidence. And it's not, you're absolutely right, it's a binary question. It's not a discretionary matter. I mean, that was dealt with some years ago in other authorities. So it's not a question of the court exercising a discretion as to what's in the public interest. You have two questions to answer. Is it the public benefit question, the public interest question? But you can only answer those, I say, on evidence. And I say at the moment is you've got no evidence in which to answer in the appellant's favour under Section 15.
Well, there is evidence of the broadcast and what it said, and the evidence as to it being a political rally, etc. So there is some evidence. You say not sufficient. I understand that.
Well, I say on that I ought to have my argument at trial, or I ought to win the case today, but I don't have permission to pursue that argument.
Well, I'm right, aren't I, that you didn't apply for summary judgment?
No. Well, I haven't got anything to apply for summary judgment on. I did submit that the judge ought to declare, I did submit that the defence wasn't available. I didn't ask for a declaration to that effect. I didn't apply to strike anything out because I haven't got a pleaded defence. I don't even know the structure of the defence. But one of the points is that with what's been placed before the judge, it's not a question of saying, I don't have any arguments at trial. On the evidence, I say, Mr. Speaker doesn't have any arguments at trial. But
So for present purposes, all you have to say
yes.
is that he didn't have enough evidence.
He didn't have enough.
Win on a point which he had
Correct.
to make good.
Yes. Subground 1F is I say, is a non-point about geography. The subground is that the judge erred in law in placing emphasis on the location of the public meeting where there was no support for a different approach when a public meeting took place outside the UK in the wording of the subsection in the case law. Alternatively, it was plainly wrong on the facts. But what the judge really did in referring to events in Sargodha was what I've already described, which was to look at the processes in Sargodha and make his assessment with what he called the status of the information. I can't identify in his analysis a separate point that because it's in Sargodha, because it's not in England and Wales, it therefore needs to be treated differently. He shouldn't have done that because Parliament has expanded to round the world, the types of meetings that can qualify. But I say it's a false point because I can't identify where it is the judge has done what's been said. My Lords, unless there's anything else from the court, that was going to complete my submissions on ground one. Ground two, responding to Mr. Munden. The first complaint is the judge erred in law in considering at 93 there was a degree of overlap between the matters relevant to section 15.3 and malice. He didn't do that because he directed himself at paragraph 58 that section 15.3 requires objective questions of fact. Granted, the language towards the end of the judgment allows for the submission to be made. It's always available to the advocate to say, well, the judge could have expressed himself differently or could have put a different heading to a section and so on. Well, what we say is that the paragraph 93 of the judgment, which is at page 100, all he's really doing, we say in substance, is reflecting that the knowable truth of the facts as stated by Ms. Nawaz Sharif was available to all, which includes as a subset the defendant. But the point is that it was, we say it goes no further than it was long discredited and demonstrated to be untrue. And in terms of, no, that's the first part of ground two. 2B doesn't seem to add anything. And then we get on to 2C, which was plainly wrong in holding there was an arguable case on malice that could proceed to trial. I mean, libel advocates spend months arguing about pleas of malice. There is evidence in court that, and this comes from Mr. Yousaf, there is evidence in court that the three basic limbs of what Ms. Nawaz Sharif said were untrue, and that anyone in the defendant's position either knew that or should have known that. Mr. Yousaf says that in terms. I think it was, if we look at the witness statement in it's tab 9 of the supplementary bundle. And it's page 61. At 23, he makes some points about time delay protocols and mute buttons. At 24, he says this is the evidence that he gave to the judge. Anyone in the defendant's position would have known or should have known that Ms. Nawaz Sharif...
Hang on. Why should have known? Why is that relevant?
Well, because the case, in this respect, the case on malice is knowingly untrue or recklessly indifferent to the truth.
Should have known is intended to pick up recklessness, is that
yes.
Right? Yes, I see.
That Ms. Nawaz Sharif's allegations are obviously false and misleading. And then there's a bit of engagement with the little that Mr. Changtai has told us about all of this. And then he goes from 26 to 28 to explain that World Call was not given away, and World Call was not given away in preeminent public regulatory terms in the months preceding the speech that was being reported upon. The gold smuggling...
So what do you say about Mr. Munden's answer to that?
Sorry?
What do you say about Mr. Munden's answer to that?
What was his answer?
His answer was that it doesn't matter that it was actually not given away.
Because it's
clearly
corruption.
the sting of the allegation was that a corrupt deal had been done to give it away. In the end, it didn't go ahead.
Well,
I mean, I'm not saying it's a good point or a bad point, but you ought to answer it because it's the point it's the answer that Mr. Munden gave.
Well. The complaint, the way the particulars of claim frame this is at. We're in now core bundle tab 9. You've seen the words that were spoken, they were read out to you, and we give our defamatory meaning that we're complaining about at page 126 in paragraph 20. And so we say that the natural and ordinary or inferential meanings that flow from what was broadcast here are first that he illegally smuggles gold, and secondly, that he participated in a corrupt relationship with Imran Khan while Khan was Prime Minister of Pakistan, which resulted in the claimant, in return for his political support through AOI for Khan's efforts to undermine the Pakistani state, dishonestly gaining enormous financial advantage which he would not otherwise have properly and lawfully obtained, including illicit gifts and tax rebates of tens of billions of rupees, and to require World Call a company worth 4 billion rupees at a complete undervalue without any due process.
What verb covers and to acquire?
Sorry?
What verb covers and to require?
And to acquire World Call.
Yes, but what verb covers?
Sorry.
And to acquire must be governed by something that's been said earlier. I'm just being...
Well,
It resulted in the claimant dishonestly gaining.
So I'll read it more slowly. Participated in a corrupt relationship with Imran Khan while Mr. Khan was Prime Minister of Pakistan, which resulted in the claimant, in return for his political support through ARY for Mr. Khan's efforts to undermine the Pakistani state, dishonestly gaining enormous financial advantages, which he would not otherwise have properly and lawfully obtained, including illicit gifts and tax rebates of tens of billions of rupees, and to acquire...
Well, that's what I don't understand.
I think my Lord's point is it's not grammatical.
It's not grammatical.
It says including gaining enormous financial advantage.
So it should be
and to acquire.
It should be dishonestly acquiring.
I see, yes.
But it could equally be agreeing to acquire. And we just don't know. It's not clear. But
Well, it's my responsibility.
well, don't worry about it's your responsibility.
It's my
or not.
grammar.
It's quite it's a potentially important point. You may say it isn't really,
No.
but what has been said is that the meaning complained of didn't actually matter whether he got it in the end. He did a deal with Mr. Khan under which he was entitled to get it. Now, for some reason, it didn't go ahead. But he and Mr. Khan, as Prime Minister, agreed to give him World Call for 4 billion. That's corrupt, whether he gets it or not in the end.
Yeah.
That was Mr. Munden's point. I just want to know what your answer to it is.
Well, the answer is that an aspect of the disreputable conduct that my client is being accused of is that he has acquired World Call.
Well, that's not actually what it says here.
Yeah.
Suppose it had said, I appreciate it doesn't say this either, and agreeing to allow him to acquire World Call at an undervalue. Now, the fact he didn't eventually get it wouldn't remove the sting of the allegation, would it? The sting is he does corrupt deals with the Prime Minister.
Well, But the particulars of the corrupt deals he does with the Prime Minister are three-pronged. There's the gold smuggling which stands on its own, and then there's the tax and world call.
Yes.
But if they knew that he hadn't acquired world call, and they reported and so adopted the allegation that he was given world call, which is obviously a disreputable thing to do in this context, then they would have been malicious because they knew that he hadn't got world call, even though that they reported that he did. He wasn't given it. With respect to Mr. Munden and the point made, it's splitting hairs to say that world call's a massive billion rupee, it's like Rupert Murdoch taking over Channel 4. And to say that he was given that state asset, or whatever its correct nature is, but because the sting is corruption, that counts for nothing when it comes to knowledge that what they were reporting was false. I would just say it's splitting hairs. So the answer is Mr. Munden's splitting hairs.
I mean, at the moment, there's been no ruling on meaning because we're still at the stage of without a defence. If you look at what was reported on the broadcast in relation to this, it's paragraph 21 and the second paragraph at the end. Imran Khan gave him 4 billion rupees world call without any due process. They're protecting each other. So that's what seems to be said. Is that right?
Yes.
And then do we have in paragraph 26 any of the exhibits, which are AY133336?
Sorry, I'm not sure. I'm lost. Where are we?
Paragraph 26 of the witness statement.
Oh, the witness statement.
Of Mr. Yousaf. Because, there's an appeal saying that the judge's finding on this is wrong.
Yeah.
So we, for whatever reason, have to get into the facts. But at the moment, I can't chase any of this down because I'm not sure we've even got the exhibits.
No, what's happened, I think the solicitors have been conscious of the strict age limit.
I understand that, but when you've got an appeal on a finding of fact and the facts are missing, it's rather disappointing.
Well, at tab 10, there are selected exhibits from Mr. Yousaf's witness statement.
Yeah. Well, we don't appear to have 333.
You haven't got 333.
And 336, which for whatever reason, Mr. Yousaf thought were important.
Yes. No, that's right. I mean, I'm sorry that I hadn't picked that up in the preparation of the bundles, but I was guided by the strict page limit. And
the strict page limits, of course, they're strict. But each case, if you need more, you ask for them, and you always get them.
But
say why?
Mr. Yousaf's exhibit itself is about 300 pages long, and was criticised below for being too long. I've got the body of the witness statement in there. That's the evidence that I will lead at trial. That's all that I need at this stage. We can, of course, provide to the court the exhibit if that would be helpful.
Well, no, but there may have been hundreds of pages, but he refers to 10.
Yes.
That's not very many. And if you look at line 3, it says ARY's withdrawal from the deal was widely publicised. That rather suggests that there was a deal to acquire world call at a time. Is that right?
Yes.
Right. Well, he goes on to explain there's PAI and PAI.
That's right.
And all the rest of it. So the process was embarked upon, progressed up to a certain point, and then
ARY pulled out.
Come to a conclusion.
Yeah.
We don't know what the facts are, but we know what was said about it.
Well, it was said it had been given away, whereas in fact the statutory process had stopped.
Those are the actual words used. But what's troubling me about this is that what we're looking at is an expectation that this sort of statement, which is ambiguous enough not to have resulted in a clear statement of the meaning of the imputation that's derived from it, should be monitored and fact-checked against historic cuttings in real time by a broadcaster of something which falls within, for present purposes we're assuming, falls within paragraph 12 of the schedule. And I just find that a bit difficult as an imposition on the broadcaster, not necessarily on the facts of this case, but more generally for these these categories of privileged statement.
Well, it may be an imposition, but I mean the process for that is to have a trial, to have the case pleaded against the defendant, for the witness to be called and the witness to be cross-examined, and the witness to point out to counsel what a huge counsel of perfection this all is. And it doesn't really work like that in the real world. Or the witness to tell the judge, well, no, I thought ARY had taken over World Call, or I thought Imran Khan had given World Call away, or this is what I thought. And suddenly then counsel cross-examining is going backwards. But that's the process. My submission today is this shouldn't be shut out, where I've got a witness who says it was all untrue. He's speaking from a position of journalistic knowledge in Pakistan, and he says in terms, if I knew this, then so should the others. That's the case that I simply want to preserve, to take to trial. If it's, in the end, too much of an imposition, the judge will rule. There'll be some way in which it filters out through Section 15.3 or Section 15.1 or malice, and so in the end. But at the moment, my malice plea is being struck out before the defence has even been pleaded. And I simply say it has to survive.
Can I just ask you, so that's the World Call?
Yeah.
29, all we're told about in relation to the gold smuggling and wider corruption allegations is just that they are historic, based on no credible evidence whatsoever. How does that support a claim that the other side knew they were false or should have known they were false?
Well, what the witness says in paragraph 24 is that anyone in the defendant's position would have known or should have known that the allegations were obviously false. This is a witness who comes from Karachi on page 55. He's the head of news at ARY News, the leading news channel in Pakistan, part of the ARY group of companies owned by the claimant. So he knows what he's talking about concerning journalistic information which is readily available to journalists in the circles in which this reporting is.
Readily available isn't good enough, really, is it? You haven't actually you haven't expressly conceded it, but it's clear that I think that you're not alleging malice in respect to the original broadcast. So you're really talking about checks. Once it's been said, you're saying those responsible for the subsequent broadcasts should have said, well, everybody knows that's not true. We better not rebroadcast that. And that's got to be done. I can't remember how long the rebroadcasts were, but we're talking about all within 24 hours, aren't we? The last one was over within 24 hours of the live broadcast. Is that right?
Yes, but
so available to is very tricky for you, isn't it? If it was everybody knew, it didn't have to be go away and have a look. I wonder if that's true. Everyone would know it wasn't true.
Well, the witness says everyone would know it wasn't true.
No, he says everyone would have known or should have known. You rightly identify the words, and both of you are asking us to make this decision, and all I'm asking is on the material. So if one says would have known or should have known, and then looks at the gold smuggling, all he tells us is that it was an old allegation. Well, unfortunately in this world, as we all know, some people believe old allegations and some people don't. But I mean, that doesn't tell us whether it's malicious.
But the witness is giving evidence about the knowledge that he says, functioning in the circles that they would have had. He can be cross-examined at trial, and maybe that part of his evidence falls flat. At the moment, we're just on summary judgment. Equally, he may be a convincing witness, so that the judge is left with the impression that, in fact, everybody did know this was all untrue. And it now beggars belief how they managed to create 11 package reports reporting this material, but in the knowledge that these were long discredited allegations. These are points in my submission all for a trial. Coming back to the point that my Lord Justice Underhill made a moment ago, if you think about the packages, they did know what she was going to say when the packages were made, and they made a package about it. Now, this was, the news here was the rally at Sargodha with the Chief Minister of the Punjab, and so on and so forth. They selected this short burst of Mariam Nawaz Sharif and made it into a package that they then showed once and reported.
Maybe it was the most newsworthy bit of what she'd said.
Sorry?
Maybe it was the most newsworthy bit of what she'd said.
Well, maybe, and again, that's a point we say for a trial. But so far as the malice is concerned, they made that package. Mr. Yousaf says that when they made that package, they knew or should have known that the package they were creating of her reporting what she said with no caveat was untrue. Now, if that's right, that is the case on malice based on knowledge of the knowledge of the untruth of the statement. That is in respect of the packages. The packages didn't happen as part of the live feed. The packages were a product of what the broadcast.
That bit I've got, and it's a perfectly valid point you're making, which I've taken on board, but it's not actually directed to the question I asked you, which was if it was not in fact the case that they already knew these allegations were untrue, but you're saying, well, they should have known or should have checked, or the information was out there if they'd looked for it, I'm suggesting that the time they had to do that, given that this is an event which they're reporting as part of current news, is very limited.
Well,
it's one thing to know and then put together a package which you know is untrue. It's another to say, well, you should have known it was untrue because you should have run away and done some research.
Yes, but on that question, you would then have to calibrate their recklessness as to the truth.
Yes, I see.
And you would have to decide whether they were reckless or not in rushing this out, or it was fine, they took their time, they couldn't have had a way of knowing it wasn't true, so they're fine in reporting it, or they rushed it out, being reckless as to the knowledge or not giving themselves enough time. But you have to calibrate all of that and decide whether in that situation the reporter had a guilty mind or not as for trial.
Just, I entirely understand that point. Can I just ask you the final bit on, we've looked at paragraph 24, which is would have known or should have known. And at paragraph 25 at the end, we're told by Mr. Yousaf that they must have known the substance of what follows. So is that all that is being said as to why they knew or should have known? That's how I read the witness statement, but it's just to give you an opportunity of answering the point.
Yes, Mr. Yousaf's justification for saying what he does between 23 and 25, which is finishing on the point my Lord just made, is contained in 26 through to 35. And he goes through world call, gold smuggling and tax evasion. So that's where you find the body of the evidence that will be led.
The inference with the case there is that not just someone else at the defendant, it has to be someone who knows what's being broadcast and has a role in it.
Yes.
Because you have to have the act and the knowledge simultaneously. So that's what we should read into 25. Either Mr. Chagtai or someone else who's a responsible person in the sense that they're involved in the broadcast.
Yes, that's right. And to supplement that, my Lord, of course, by the time it comes to plead malice in this case, I will have the advantage of seeing written down in black and white what the structure of the Section 15 case is and what was done in relation to the production of the packages.
Depends on the burden of proof.
But to
if you had to prove that it wasn't.
But to say that I'm speculating at the moment, or that I should be tied down by world call and corruption and so on and so forth, we need to understand how it is they came to broadcast this, before we can really reliably begin to make allegations about the state of mind in doing what they did. Because at the moment it's completely inexplicable how these packages came to be broadcast. The live feed's a different question, and I will deal with that in a moment, but it's really inexplicable why out of this event at Sargodha we had this selectivity of Ms. Nawaz Sharif's attack on Mr. Iqbal.
Could I just ask one other question about para 25, which my lord's asked you about? As he's pointed out, he says, well, someone at the defendant, a responsible employee or principal, must have known the substance of what follows. That's must have, so that's slipping away from should have, must have.
Yeah.
But then at 35, he says, all of this information was in the public domain at the time of the broadcast complaint about these proceedings and easily accessible, if not very well known. Well, that's very different from must have, isn't it?
It could be.
The same point is made at the very end of that witness statement, which is well, from matters of general knowledge, must or should.
Well, sure, I think you better keep any points for reply because time is short for.
Now, I've got 15 minutes, I think, to be fair. So if I may move on to the respondent's notice,
yes,
that would be convenient.
Well, if you've said all you want to say about malice.
I think so, yeah. Now, these are quite short points, and ground 3 of the respondents put forward is to do with the conclusions the judge came to that I haven't got a realistic prospect of showing various things at trial. Ground 1, which is that this whole exercise was inappropriate for summary judgment, it's largely going to fall, I suspect, from everything that we've so far discussed. You're either going to, you'll agree with me about that if you think some of my criticisms get home, but you won't agree with me about that if you think that everything else the speaker says is right. So I'm not going to make a big excursion out of ground 1. It comes last in the skeleton argument simply because it seems to me the most appropriate place to put that point. But I would ask the court before, while reflecting, to reread the subground of ground 1, because this does seem to be a process that has got rather out of kilter in terms of a summary judgment application. But back to ground 3, and there are 4 points to make. There's first of all the judge's conclusion at 42 that this was a public meeting that qualified under paragraph 12. Then there is the live feed as a report, which is is paragraph 47 of his judgment. And then there are 2 points in relation to fair and accurate report of proceedings. First of all, in relation to the packages, and then secondly, in relation to the live feed. Let me start with the first of those points, which is that the judge concluded that what happened in Sargodha was a public meeting bona fide in lawfully held for a lawful purpose, and for the furtherance or discussion of a matter of public interest. What he does, or the way in which he goes about that, we say is fundamentally flawed. If you go to paragraph 37 of the judgment, which is at page 86, he sums up or paraphrases some of the defendants, the appellant's factual account. Nobody actually went to this event, so this is all given in some way or another second-hand from the defendant. Then at 38, the judge summarises some of the evidence that was given from the respondent, in particular Mr. Youssef, who we were looking at earlier, but in a different section about the meeting. There is then at 39 to 41 quite a lengthy citation of McCartan and some discussion of the notion of a press conference, which is not part of the reasoning process.
Well, it's not only about it being a press conference. I agree. He seems to set out more of this than he need, but there is bits in it about what the rationale behind the public meeting.
Exactly, and I don't say the McCartan is limited to press conferences. It's obviously about public meetings as well. And then at 42, we arrive at the judge's announcement that that paragraph 12 of the schedule is satisfied, or at least he doesn't think I've got a realistic prospect of demonstrating to the contrary. Now, what we say about that in general terms is that that is against the weight of the evidence that we provided, in particular Mr. Yousaf provided, in relation to the event at Sarkodha. We do say quite a lot of this, and I'm going to go into the detail in a moment, is evidenced by the appellant, or where it is evidenced by the appellant, he ought not to have been going on the appellant's evidence anyway, because this is a summary judgment application. What, in effect, he's done in paragraph 42 is announced the result of a mini-trial that he has conducted by, on the one hand, taking into account those parts of the appellant's evidence he thought were most reliable, on the other hand, taking into account those parts of my client's evidence he thought were most reliable, drawing a line down the middle, and telling us what his judicial conclusion is. He's effectively weighed the evidence up and not taken into account the bits that he didn't see. So, for example, he says at 42A, this was an important political rally. Well, this was a rally according to the evidence that he had to garner support for the party. Mr. Yousaf goes into some detail about the way in which these events take place, the threats of violence, the way in which opposition isn't brooked, and so on and so forth. So already there's a major question mark against the judge's reasoning there. He ought to have accepted our version of events for these purposes. He then says that at paragraph B, this was held for discussing matters of some importance. Well, the Chief Minister of the Punjab was there. We're not complaining about him. We're not complaining about most of the other things that Ms. Nawaz Sharif said. So far as the three paragraphs that we are complaining about are concerned, we do say they're not. There's no case that allows him to come to the conclusion on this basis that they were discussing matters of some importance. There's also, he does there say in B, the rally would also have been held to gather support for the party, but that's obviously not anything which is catered for by section 15.3. There's nothing in section 15.3 about events that are to rally support for a political party. There is the lack of evidence. We say that this was a lawful meeting, which is the conclusion the judge came to in paragraph C, but there's no evidence at all before the court that this was a lawful meeting. There's no evidence from anybody who called it or what it was proposed to be, and so on. And at paragraph E, he says that in theory anybody could attend, although I acknowledge that is more likely that only party supporters would have been present. Whereas in fact the evidence before the judge in terms of the warning notice said that there was going to be violence, and Mr. Yousaf records that nobody is welcome at these meetings unless you are a member of the PMLN. Those are essentially headline points, but what we say, where we say the judge was wrong, but the process in paragraph 42 is not the process of identifying whether or not there is a realistic prospect of a case being developed, whether it's on the evidence or argument at trial. The process in paragraph 42 is in effect evaluating the written evidence, not subject to cross-examination in either direction, but evaluating the written evidence he's got and doing the best he can to come out with a compromise account of what went on in Sargodha, and then applying the Act to that, and concluding that leaves me without a prospect of arguing to the contrary at trial. And we say it was simply wrong to do that mini-trial, and the errors that he made invalidate the conclusion that he came to. We will, if we go to trial, have an argument about this because he didn't make any declarations against me. But since we're here, it's another reason why he shouldn't be given summary judgment. The next point is about the second ground is the judge's conclusion at paragraph 47 that the live feed was a report. Well, the authority that we gave him on that was Jakarta at 669G, and I've also included in the bundle at authorities 19, Duncan and Neil, which is talking about reports at common law. But the law argued for by the appellants simply isn't the position. There is the requirement for a report to be a précis or a story, or to relate what has happened at an event. It can be a contemporaneous report in terms of court reporting. The court reporter says, well, this is what happened at the Supreme Court this afternoon. But if you elevate this live feed into a report, then first of all, you're going against any assistance that the authorities offer. Secondly, you're providing a Section 15 defence in live broadcasting, where Parliament's decided to provide a live broadcast defence in Section 1 of the 1996 Act, which is the point I think we began on this morning. Live broadcast is about the broadcaster's responsibility for the publication and the care that's been taken in the broadcasting and so on. But to offer a live broadcasting privilege, we say would turn Section 15 on its head. It would take out of account malice, for example, as my Lord Justice Underhill, you mentioned that you mentioned malice a moment ago in the context of live reporting. It would disable Section 15(1) in terms of malice if the live report could be privileged. And so we say simply what the judge ought to have done. There was only really one thing to do in this case, which was to identify what's said in Jakarta at 669G, read Duncan and Neil 1727, and conclude that a report had to be a précis or something similar, making the live broadcast privileged. As I say, would ride a coach and horses through everything we've been discussing today. If it turns out that live broadcast can give rise to a privilege, then I would like to see how the privilege is pleaded before formally conceding that I can't plead malice in respect of it. But at the moment, because I can't see how live report can attract privilege, I simply say that the question of malice doesn't arise in relation to the live report. But
just picking up something that troubled me when I first read it, suppose the appeal fails, so the matter goes ahead.
Yeah.
The fact the judge has found against you on all of these, on these 3 points where he did find against you, that's not binding, or is it binding?
It's not binding. I think there's quite a strong judgment from Mr. Justice Saini in the KBD on that point. And so what would have needed...
So all these points will still be open to you. You may
Yes.
have them. Obviously have Judge Lewis's judgment
I've got an uphill
used
struggle.
against you as persuasive. That's all.
Yes.
You'd make the same points, wouldn't you?
I'd make the same point.
He's conducting a mini-trial and we're having a proper one now.
Yes.
Yeah.
Exactly. But formally, these points are open to me. The reason
Yes,
they're raised
but I
now
just wanted to double
is
check.
because there are further reasons why he ought not to have granted summary judgment. He shouldn't have given summary judgment under Section 15(1), which is in effect what he did by finding that the meeting qualified. But
Well, he doesn't know. Yep.
and then
But if he'd, sorry to prolong this, but if he'd decided, or it had been sought and he'd agreed to give summary judgment on an issue,
yeah,
then the position might be different.
it would be. There'd be a
He hasn't
declaration
really given summary judgment on 15(1). He has simply
expressed in
declined to give summary judgment, so all bets are off.
Yeah.
Well, that's certainly my analysis. And I think the Mr. Justice Saini case I cited in an argument about what I should have permission for. So it's escaped me at the moment. But I think that is the position. Yeah.
Well, if Mr. Speaker wants to take issue with that, he can do so.
And then finally, if I may, very quickly, I appreciate time is up. The final two parts of the respondent's grounds, excluding the submission that this ought not to have gone ahead as a summary judgment anyway, is that the problem generated in this case by the lack of a defence, the lack of a definition about the proceedings which are being reported on, and as a result, the judge at different times in the judgment, at 42 he referred to the proceedings as the rally, at 47 he referred to Ms. Sharif's address or Ms. Sharif's address with further coverage of the rally, at 48 he referred to the entire rally or just the main speakers, and at 54 he referred to what Ms. Sharif said about the claimant.
Yeah, all of those. I haven't understood what the point is here when I read it. All that is true, but so what?
Well, the privilege applies to a fair and accurate report of proceedings.
Well, the proceedings is just another way of saying what happened at.
Yeah, but was it what happened at Ms. Nawaz Sharif's 3 paragraphs, or her speech, or the whole day in Sargodha? Or, because I'm complaining about select extracts from them. And the problem that there is then, without the definition of what proceedings it is that the defendant is claiming a privilege for reporting, is the judge, I say, can't sensibly get to a conclusion about fairness and accuracy until he's defined the proceedings. He hasn't got a defence to lead.
Well, surely he has defined the proceedings. I mean, he may have used different words. He means everything that happened at the rally.
Well, everything that happened at the rally, Ms. Nawaz Sharif spoke for 45 minutes an hour, something like that.
Well, you could have a ground of appeal that, or a respondent's notice ground that says that this wasn't fair and accurate. But I don't understand that to be your ground.
We say the exercise is flawed because of the. It is part of the respondent's notice. We say the conclusion is a flawed one. If we go to.
Yes, but unless you then condescend to particulars and say, look, there were 3 hours and lots of other things were said, none of which get mentioned, and therefore it wasn't a fair and accurate report. That's fine, I understand that point. But I didn't understand that to be the point you were making.
Well, I think it is.
Your point is that they only focused on this last quarter of an hour, or 5 minutes, or 3, whatever.
5 minutes or whatever it is. But no, the point might be a more subtle one than that, which is that I'm entitled to be given an account of the proceedings which are being reported, which the defendant is arguing are fair and accurate. At the moment, I've not been given that opportunity. I mean, this fell on deaf ears before the judge. I said that the lack of definition of the proceedings was a fundamental problem in identifying what had been reported, or what was being reported on, and what was fair and accurate. That doesn't find its way through into the judgment. I repeat the point now. But until I've seen a defence which identifies the proceedings, I say any exercise in sitting back and saying, well, that was a fair and accurate report of whatever went on in Sargodha, is really an unfair and futile one, because we don't know what we're talking about. Are we talking about the whole morning? Are we talking about 5 minutes?
We've got the point. Okay. But time is short, as you say. Before we finish on, well, even if we have cut you short on respondent's notice, I think there may be another aspect of malice on which we ought briefly to hear you, which I don't think you addressed at all the point about Harkham, did you?
Well, I've addressed it in the supplementary skeleton argument.
Yes, fine. Well, that's all you want to say about it, but that's fine. And I think we're very happy to. I just wanted to make sure that it wasn't under the pressure of time. You hadn't wanted. Were making all submissions.
To be clear, I don't think I'm majoring on spite for malice. But if one looks at paragraph 378 of Harkham, I don't think Miss Justice Nicklin needed the words in parentheses, perhaps unusual and rare. In the case where the reporter knows the facts in an otherwise fair and accurate report are nevertheless false, or is reckless to a degree that the law treats her as having such knowledge, then she would be malicious.
That's your answer really is that, that paragraph. Okay.
My question, and there's a short answer to this, I think, is whether you're maintaining that Mr. Justice Nicklin was wrong to exclude dominant improper motive. I think your whole case is knowledge of falsity.
Well, but knowledge and falsity, but it may be there is room within Miss Justice Nicklin's analysis for inferences that go along with knowledge of falsity. So other aspects of motivation, which might not drop directly into Horrocks and Lowe, are nevertheless legitimate criticisms if you're dealing with a broadcaster who is either knowingly or recklessly publishing false information. So I wouldn't want to give up on Hark. I mean, I'm not sure it's entirely clear, but front and centre is definitely knowledge of falsity. And, we all know there's been a long debate about whether Spike's gone out altogether, but there are intermediate points that can legitimately be made, I would say, as a matter of pleading, which possibly do hang on an inference, which comes from the knowledge of falsity, which is, in terms of, just finally, in relation to the judgment, you'll see that what His Honour Judge Lewis did have, if you look at page 100 of the judgment, is he recorded at 87B, my formulation, or one of my parts of my case, was formulated as new when it broadcast its allegations. They were untrue or was reckless indifference to the truth of the allegations. So to say that that wasn't before him or that we've somehow evolved isn't accurate. Others of these, A to F, may be crossed out or rearranged and so on and so forth. But that's the skill of the pleader when the time to plead the case arrives.
Right. Now, I don't think it matters we've lost a little time because you were actually very economical on respondents' notice points. So Mr. Speaker will obviously have to deal with conventional reply, but he won't need to be very long on your respondents' notice because you weren't.
No, my lords. Firstly, it's not correct that this claimant had to sue in England over overnight snippets which caused no damage. There's no pleaded case on actual serious harm. He has his own TV channel which broadcasts them. He could have sued Miss Sharif in her jurisdiction. He could have served process on her here. She's in London today. So it's artificial to claim that he needed to protect his reputation here over snippets broadcast overnight which caused no harm. In respect of my learned friend's submissions on section 15, this is an interpretation which will needlessly complicate a branch of the law where legal certainty is of prime importance. Not my submission, that's Lord Stayne in McCartan. An interpretation which will needlessly complicate a branch of the law where legal certainty is of prime importance, 207C. But it is relevant here. None of my learned friend's arguments on his feet today appear in his skeleton argument on section 15. None of them appear in other authorities, or he didn't derive any support from other authorities. They're afterthoughts to get around the problem that these broadcasts are privileged. This court is highly experienced on statutory interpretation and the various ways in which statutes are to be interpreted. The drafting method chosen by Parliament for section 15 is a standard one. It appears in Benyon as an accepted form of statutory drafting. It is one where one sets out a provision of general application with exceptions. And as I was saying this morning, the general application, the defence is there in section 15.1, subject as follows. And then it has the exceptions or the limitations. And they should be exceptional, they should be limits upon the defence, a fair and accurate report of an occasion that Parliament has decided the media should be entitled to report. One doesn't start the interpretation of the statute in the middle of it, and I know of no other statute where one does start in the middle of it. moreover, this court is an appeal court, and as as Lord Justice Warby said, one has to have regard to an interpretation of a statute that would apply in every case under Section 15 of the Defamation Act. That means in respect of every report in a court, every report in Parliament, every occasion set out in Schedule 1, Parts 1 and 2. And it just cannot be right that the media must start with an analysis of the particular information, that they must get hold of whatever the report or the speech is and start to analyse the particular information that a claimant might complain about or might be mentioned, and start to test that in respect of public benefit and public interest before one can produce a fair and accurate report. This is all about setting up more and more hurdles, and they're technical and artificial hurdles. Indeed, my learned friend was absolutely blunt with what he said. It was you could not report a foreign speech live under Section 15. Does not qualify. So one couldn't report live what the President of the United States was going to say on an inauguration. And as I understand it, he was also saying in respect of the facts that one should look at for public interest and public benefit, that one has to consider what a journalist may have knew or found out in something like a Washington Times article from 20 years earlier. This is all about setting up more and more hurdles for the media in reporting speech in circumstances in which Parliament has given them an entitlement to, subject to the protections set out in Section 15 and only set out in Section 15. And therefore, that is why the interpretation of Section 15 that was impressed upon you today for the first time and not set out in the skeleton argument and not with any support from any authority is simply wrong. In respect of malice, my learned friend didn't challenge my Lord Justice Underhill, suggesting that they are conceding malice in respect of the initial broadcast. He didn't challenge that. But one has to understand in respect of malice that it is a guilty state of mind. It is a state of mind tantamount to dishonesty. And given that they cannot fix malice in respect of the initial broadcast, they have to fix a guilty state of mind after the live broadcast and before, well, which one? The first, second, third, fourth, fifth, up to the 11th. They have to identify that someone acted with a malicious state of mind, not simply that they considered it to be newsworthy. And there's two fundamental problems that arise from my learned friend's submissions. The first is, if you cannot even work out what the words are in a meaning and the particulars of claim, the idea that a journalist is going to be fixed with malice in respect of deciding that it is something that should be reported or not reported in respect of falsity or not is an exceptionally high hurdle and an unfair one, and for one which there's no evidence. And secondly, should have known is not recklessness, should have known is equivocal, should have known is negligence. Should have known, it's been said for as long, I think Belmont Finance, it was said in the Court of Appeal, and I'll try to pull it out, but it said in all of the malice cases, knowledge, should have known is not knowledge, ought to have known is not knowledge, it's negligence. And the evidence put before the court below was should have known or knew, and that's equivocal, and that's not malice. And as was considered, and I'm going to go to the Greenstein case very briefly, but it was set out in Hooder and Wells, the inference on malice must be more consistent with the existence of malice than with its non-existence. And if you concede that it is something that you didn't know but should have known, then it's not consistent with the presence of malice rather than the non-existence of malice. That's the end of the point. And that is why malice is a serious charge tantamount to dishonesty. And you have to have, before you draw the inference, specific facts from which you can allege. You have to identify facts or matters which it could be inferred it is more likely or not that these journalists knew and these journalists published out of a guilty state of mind. And that is entirely absent from the evidence. And that was the point made by my Lord Justice Dingemans in the Greenstein case, which is in the bundle, paragraph 26 of tab 16. The main point taken at paragraph, this was concerned with the Rehabilitation of Offenders Act and whether the reference to a spent conviction in an article was malicious. And the requirements for pleading of malice are set out at paragraphs 15 and 16, that they are strict and they must be more consistent with the existence of malice than with its non-existence. And then the relevant allegations are set out at 17. And what I just draw attention to first is 17.1, the defendant's motive was to smear the criminal, the claimant as a criminal, and then it was the inclusion of the convictions. Points made at paragraph 20. The main point is taken at 22, and then at 24, the right to strike out the plea of malice. The introduction did no more than recite the legal test for malice and assert that it was satisfied. Many of the particulars, in truth, were mere assertion. The defendant's motive was to smear the claimant as a criminal and did not advance the defendant's case. What was lacking was the identification of any facts or matters from which it can be inferred that it was more likely or not that these convictions had been published for some irrelevant, spiteful, or improper motive. That is the crucial difference between malice, a guilty state of mind, and negligence or irresponsible journalism. And if one looks at the summary that the judge gives in his judgment of the points that were being made by the claimant below, they're set out at paragraph 87 of his judgment on page 100. First one is an assertion of misuse any privileged occasion with its dominant improper purpose or motive being to damage the claimant's reputation by its broadcasts. That's mere assertion, exactly as Lord Justice Dingemans identified in Greenstein. 87 is that knew when it broadcast its allegations they were untrue or were recklessly indifferent. Well, the evidence doesn't say they knew. The highest the evidence goes is equivocal. That a journalist could have found out. 3, failed to exercise conscientious, responsible and reasonable journalistic endeavour which would have uncovered the falsity of allegations. Negligence, not malice. Unnecessarily, gratuitously and opportunistically repeated the allegations, mere assertion. Failed to comply with all relevant journalistic and broadcasting norms, nor take any steps to verify or check the allegations before broadcasting them, failed to include the claimant's side of story, failed to adopt a balanced or measured tone. Negligence, irresponsible journalism, not malice. Could not have held the belief that publication in the public interest was reasonable, irrelevant, assertion, and not malice. These paragraphs largely equate to what the respondent sets them out in his skeleton argument at paragraph 43.2. I've taken them from the judgment, but they're in the respondent's skeleton at 43.2. They don't amount to a case of malice, and the evidence before the court, when it concedes should have known, is equivocal. And therefore, there's not even a basis to plead malice on an equivocal acceptance that they do not know whether they knew. And therefore, the judge should have so ruled. In dealing with the respondent's notice, the judge's finding that the meeting or the rally was a public meeting was a finding of fact that was plainly open to him on the evidence. And we addressed this in the supplemental skeleton argument. paragraphs 17 to 22. It's 163.
If you were saying to strike it out, it's not just it was a finding of facts open to him on the evidence, it's got to be the only evidence.
Yes.
Oh, wait, I'm getting this up.
Well, no,
Sorry?
in the Greenstein case, Mrs. Justice
sorry.
Tipples at first instance struck it out, and it was upheld on appeal.
I'm so sorry. I'm forgetting this is a respondent's notice point. We keep going, yep.
On the public meeting point,
Yes, on the public meeting point. That's what I was asking about.
On the public meeting, we submit this is something of an unreal and artificial point to be taken, because everyone watched the video, and there's no dispute what we were watching. We are watching a public meeting discussing politics. It was organised in advance. It was arranged. That is what the evidence said, and it was plainly open to the judge to rule that it was a public meeting, as he did. And we cite in the supplemental skeleton at Gatley that a meeting of electors is the clearest possible example of a public meeting within the section.
I should perhaps confess, or confess is the wrong word, I wasn't able to watch the video which you supplied us with because I didn't find the password anywhere.
Oh, I'm
but
sorry.
If you want me to, you have to send me the password.
I think I've got the password, unless the password is all different for each different.
Well, you can watch on my own.
Yeah.
Okay, all I'm trying to say is I didn't want you, if you thought it was important that I watch the video, I will, but I haven't yet.
We said the judge's finding is correct on this point, and that one can see it from the public from the video, and it's unreal when one can see. It's a bit like the live recording of this court, and Mr. Barnes saying, you can't just look at the live recording, we need to have a witness statement from someone explaining where everyone was sitting. One can see it. The evidence is there from the video, but more to the point, the evidence wasn't really in dispute what this meeting was and what the purpose of this meeting was for. And as I said, we make those points in paragraph 160, in the skeleton argument, which is page 163 of the core bundle, from 17 to 21. Including the fact, as said, that a meeting of electors at any constituency to hear an address from a parliamentary representative or in this sort of thing is the clearest example of a public meeting within this section. Again, if one looks at the way that the House of Lords dealt with these things in McCartan, a technical approach which requires a defendant to jump over a large number of hurdles is not what the House of Lords had in mind in McCartan on this point. And we also say, in respect of the live broadcast, the argument that this is not a report is wrong. Cannot say the judge was wrong at this. He makes a factual finding at paragraph 47. Sorry, I think it's page 47, paragraph 29. Maybe. No, I'm not sure about that. Hold on. Sorry.
I think it's an earlier paragraph. 47, is it?
47, my lord, my apologies. It's page 90. The fact that the report is broadcast live does not take in itself take that report outside the scope of the privilege. However, what was published or live in the report will be fact specific. The live footage was broadcast as part of a rolling news programme, signpost earlier in the programme, and the live relay was enhanced with a rolling ticker. So he is making a factual finding on that. But the main argument that is put against us is something that Lord Justice Ward said in Chickota, and I should just go to that, which is at page 669 of the authorities bundle. No, it can't be. It's at tab 7. .76 of the bundle is 669 internally. What is being said here at F, what constitutes a report, is looking at the first two sentences and then drawing a distinction within the third sentence. And in the context of what was written in that paragraph above in the newspaper, His Lordship says it is a report if it's an account or a resume of proceedings. There's no limitation of time or editorial.
Sorry, I've got the wrong page. Which internal page?
669.
Sorry. Yep.
What constitutes a report? His Lordship starts with the actual article under consideration. The first two sentences, 3 High Court judges were executed, and then the fact that there's a third sentence which deals with events that followed and cannot be regarded as a report. And considering that, he's looking at whether a report, as in 2 sentences, can be an account or a resume of the proceedings. But he's not laying down a definition of what constitutes a report.
Yeah, but it must be read against the facts of that case. And what was the issue in that case?
And moreover, Lord Justice Neal, earlier on in 665, C is more expansive. He was referring to the purpose at C, but the purpose of the statutory defence is to enable the public to be informed, usually by a brief summary of proceedings of importance and interest, which is the nature of things few people could have attended. But they're not laying down the scope of what comes into a report. And insofar as Lord Justice Ward, what Lord Justice Ward is saying, Lord Justice Thorpe agrees with Lord Justice Neal, but doesn't expressly agree with that resume.
I mean, if it was a complete transcript, given the technology of the time, that would be the equivalent of a live broadcast.
And we say a live broadcast is the very best means by which to inform people about what happens at the event, and the best evidence of that is happening today. Moreover, there is a statutory language change in the qualified privilege defence, which existed only for a report in a newspaper, was changed in the 1996 Act to cover other mediums. And therefore, if Parliament was looking at the ability of other mediums to report, it's looking at more than how it is set out in a hard copy. And the final point which we make at paragraph 28 of the skeleton argument is it's the view of the authors of Gatley that it would be clearly protected. So we say there's nothing, the judge was right about that, and there's nothing in any of those points. And the final point really was about proceedings, and this is another technical or artificial argument raised about how one is supposed to define the proceedings. It's quite clear from the McCartan case that proceedings were being defined by their lordships there to ensure that what is reported and what one has the protection for the reporting are what Parliament has deemed should be reported under the Act and in the schedule, and not matters outside of that. For instance, interruptions in a courtroom, or discussions between individuals which are not part of the proceedings. That's what the phrase is there to protect against. It's to protect against impromptu disruptions of particular proceedings and arguments that it would be privileged to record what people were shouting from the crowd, or are not doing so, but might be shouting from the viewing gallery in a courtroom and such like.
So that's what is there to protect against that?
The fact that it refers to the proceedings.
Right. But I thought that's what one of the things you said about section 15.3.
But
the irrelevances, things that weren't within the scope of the public interest that was the purpose of the meeting.
Well, I think if there's a distinction that can be drawn, it's by the individual themselves who's the subject matter of the fair and accurate report, which is the public benefit and public interest point. But the fact that it's only speech within the context of the proceedings means it couldn't be someone standing up and making an impromptu attack.
Yeah, so you could have something that was part of the proceedings, but was not a matter of public interest.
Well, if someone stood up at the back who was in the gallery here and started to shout, one couldn't say, if it was reported that it was a fair and accurate report of the proceedings in court, because it wouldn't be part of the proceedings in court. And I think that is what is intended to be caught by the wording.
I don't know about that. What about the reactions of families of the deceased in criminal trials, which are then reported? Anyway, it doesn't matter.
Or hecklers generally.
Well, fortunately for the purposes in this case, we don't have to worry too much about whether privilege would apply to a heckler. But if there is a purpose for the words in these proceedings, it is because it is looking at, in this case, those who were speaking at the public rally and those who went to hear those particular individuals. My lords, unless there's anything further, those are...
No, thank you very much. You've built yourself in a rejoinder. No, not really a rejoinder.
Reply on the respondent's
reply on the respondent's notice.
Which actually, having been built in, I think probably is unnecessary. I've got one point of information on the respondent's notice, which is I referred on the question of the non-binding nature of the judge's points on which he was against me, those four unfortunate paragraphs. The case is noted at 24.3.1 of Volume 1 of the White Book, and it's called Executive Authority against Prime Education. It's Mr. Justice...
Against what education?
Executive Authority versus Prime Education.
Prime, thank you.
And it's 2021 EWHC 206 QB, Mr. Justice Saini.
EWCH QB
206.
206, thank you.
And the editors note that whether the judge decides to make such a declaration on the sub-issue or simply leaves the issue for the trial judge will be a fact-specific case management decision to be undertaken following assessment as an exercise of discretion in accordance with the overriding objective. But from about paragraphs 130, I think it is, onwards of Mr. Justice Saini, he comes to the very clear conclusion that unless the court has made a declaration on a sub-issue, everything is alive for trial.
Thank you very much.
Well, could I raise one point with you, Mr. Speaker? You've referred a couple of times to Bennion, but I don't think you've given us a reference.
I have one copy, but we will send it up. Can I just ask on that point? We have hard copies of the judgment, my lord, Justice Dingemans.
The Hong Kong one?
The Hong Kong one.
Or why not hand those up as well?
I will hand those up. Do you want all the other exhibits?
No, just the 10 pages that are referred to in the... actually referred to only about 10... Yes, it was about 10 pages that he referred to. But it was very difficult to read it without seeing those.
If we could have that material electronically in due course, it would be...
Of course, we can hand up hard.
What you've got hard here, we may as well have now.
Yeah.
And we will send it electronically, the judgment and also the section from Bennion.
We seem to be usherless. Well, I tell you, the judicial assistant, the gentleman with the beard, will take them and bring them to us afterwards.
We'll give them to you.
Right. Thank you very much indeed. Oh, sorry, the usher was there all along. Sorry, I was looking. I thought I couldn't see anyone. Well, we'll have them now. It's a one copy of Bennion.
It's one copy of Bennion.
We'll
I can make more and send.
No, don't worry. We can get those made. Thank you very much. Very well. We will, of course, be reserving our decision. We're most grateful to Council and the teams behind them for their helpful submissions on obviously an important and sensitive case. The draft judgments will be circulated in due course to Council on the usual basis. Just to spell that out, they're being circulated only
for the very limited purposes identified in the Counsel General for Wales case, and they should only be circulated beyond counsel to the extent necessary for those purposes. And if there's any departure, if they're circulated more widely or for any other purpose, that may well be a contempt of court. Thank you all very much.